May I please request everyone to settle down so that we can start the session now? Namaskar, distinguished guests, learned speakers, respected members of the bench and the bar, eminent academicians, and dear colleagues. I, Preeti Sharma, on behalf of the entire DAW 2025 committee, welcome you to today's deliberation on environmental concerns in investor-state dispute settlement. The arbitration game, an article in The Economist 2014 expressed, if you wanted to convince the public that international trade agreements are a way to let multinational companies get rich at the expense of ordinary people, this is what you do. Give foreign firms a special right to apply to a secretive tribunal of highly paid corporate lawyers for compensation whenever a government passes a law to say, discourage smoking, protect the environment, or prevent a nuclear catastrophe. Yet, this is precisely what thousands of trade and investment treaties over the past half-century have done through a process known as Investor-State Dispute Settlement, or ISDS. That concerns today's topic. We have on our panel today Mr. Mahesh Rai, Director of Dispute Resolution and Deputy Head of Construction and Engineering at Drew and Napier in Singapore. He has been engaged as a counsel in high-stakes international arbitrations and litigations in the field of energy, construction, and infrastructure sector, representing states, investors, and multinationals under all major institutional arbitration rules. Next, we have on the panel Mr. Aditya Singh, who is a partner at White & Case based in Singapore and an adjunct associate professor at the National University of Singapore Faculty of Law. Mr. Aditya has an extensive experience in ISDS and has represented the Republic of India, the Kingdom of Saudi Arabia, the Republic of Uzbekistan, and the Russian Federation in investment arbitration and related litigation matters. Mr. Aditya is qualified to practice in India, New York, and England and Wales, and he worked in White & Case's New York and London offices for several years before moving to Singapore. Next, we also have on our panel Mr. Sudhanshu Roy, who is a member of the International Litigation and Arbitration Practice. His practice focuses on investor, state, and international commercial arbitration, as well as arbitration-related litigation before US courts. He represents sovereign and private clients before arbitration panels administered under the ICSID, UNCITRL, ICC, and SIAC arbitration rules. Before joining Foley and Hoag, Sudhanshu worked as a legal advisor with the International Investment Division of Department of Economic Affairs, Government of India, where he was instrumental in the drafting and development of the revised Indian model bilateral investment treaty and negotiation of several international investment agreements. Also, we have on the panel today Ms. Ashwita Ambast, Senior Legal Counsel at the Permanent Court of Arbitration. With her wide-ranging experience in investor-state disputes across the globe, she brings an insider institutional perspective on that one that promises to spark fresh insights in today's deliberation. To chair this session, we are truly honored to welcome Honorable Ms. Justice Indu Malhotra, former judge of the Supreme Court of India. A trailblazer in every sense, she was the first woman elevated directly from the bar to the Honorable Supreme Court. Post-retirement, she continues to shape arbitration jurisprudence as a full-time arbitrator in both domestic and international matters and serves on the court of the Permanent Court of Arbitration at The Hague. Please join me in warmly welcoming Honorable Ms. Justice Malhotra and the learned speakers. Thank you.
Good evening to the esteemed members of the judiciary and also the distinguished guests who have come from overseas and India to attend this seminar. We are going to address and we are going to give a different perspective, each of us, on the issue of environmental concerns in investor-state dispute settlement. The perspective which I intend to speak on is the perspective from the global south. During the past 2 decades, the number of ISDS cases arising out of state action taken on account of climatic change and environmental issues has increased significantly. Foreign investors have invoked ISDS mechanism to challenge climate and environmental actions taken by states, particularly developing states, and have made huge claims for compensation. As per the 2023 UNCTAD report, there are more than 127 ISDS claims which have been filed by foreign investors seeking 1 billion crore or more in damages. Some notable instances which I'd like to mention. One is a case where 3 Australian mining corporations filed a claim for $37 billion from Congo, which was 3 times the state's GDP of 2021, on the ground that, no mine, even though they had not carried out any mining activity whatsoever, and, despite having been granted licenses, but they made this humongous claim against Congo. Another example which I want to give is a 20 billion claim made by a US-based company called Ruby River Capital against Canada for refusal to approve a liquefied natural gas project. A third is a 15 billion claim made by TransCanada Energy against the US for refusing to approve an oil pipeline. Some measures, such as refusal to grant oil and gas exploration permits, phasing out of coal-fired power plants, denying permits for large mines, and strengthening laws to protect water supplies have resulted in claims under the old generation treaties. And as you would know, that India has terminated its treaties in 2016, but yet we are facing the blast of these claims which are being made under the sunset clauses. And the sunset clauses have extended the protection to foreign investors for periods ranging from 10 to 15 years. The ICJ on 23rd July 2025 has delivered a landmark advisory opinion on the obligation of a state on climatic changes, wherein it has opined that international law obligates a state to prevent significant harm to the climate, and failure to do so can trigger legal responsibility. The ICJ has said a state's failure to take appropriate action to protect the climate system from greenhouse gas emissions, including through fossil fuel production, fossil fuel consumption, granting of fossil fuel exploration licenses, or provision of fossil fuel subsidies may constitute an internationally wrongful act. The advisory opinion of ICJ has major implications for international investment law, and Justice Sarah Cleveland, in her separate opinion, has said that investment treaties cannot be interpreted in isolation, but in harmony with international climate law. While international law obligates a state to protect the environment, foreign investors have been invoking the ISDS mechanism to make these huge claims on the purported ground of speculative future losses, indirect expropriation, or unfair treatment. These are the clauses which they are using to say that, we are entitled to make claims. And the way forward is, one is, of course, terminating the old generation treaties, which is also not an easy task. It has happened with respect to the Energy Charter, where a lot of states have been able to terminate these sunset clauses. And it's also important that going forward, there are incorporation of carve-out clauses which are incorporated in these treaties to address environmental issues and climatic concerns. India's position since 2016, we had come out with the model BIT, and Article 23.2 of the model law expressly limits compensation to actual loss, excluding incidental or speculative damages, because they have been claiming for future losses, even without having put in the commensurate amount in this country. And these carve-out clauses have been incorporated in the India-UAE BIT and in the Brazil-India Investment Cooperation Facilitation Treaty and in the India-Kyrgyzstan BIT. But the major countries, we still need to move forward on that. And the majority of claims the challenges are basically on the hope that it is a legitimate expectation to have obtained such profits in the foreseeable future for decades. And interestingly, the Nobel Prize winning economist Joseph Stiglitz from Columbia Business School has described the ISDS mechanism as litigation terrorism. Developing states are particularly vulnerable because they have old generation BITs which contain strong pro-foreign investor protections with no provision for safeguarding environmental or human rights issues. Developed states, interestingly, have taken steps to protect themselves from ISDS claims. States like Canada, the US, and members of the European Union are eliminating their exposure to ISDS claims, but have preserved their ability of their investors to continue to extract wealth and exploit the global south through continued use of ISDS claims. And that is why it's a measure of serious concern. In the renegotiated trade agreement between Canada, the US, and Mexico, which was entered into in 2020, the ISDS mechanism has been done away with. The Canadian Foreign Minister, Ms. Chrystia Freeland, she remarked, the investor-state dispute resolution system that has allowed companies to sue the Canadian government is also gone between Canada and the US, known as ISDS, but it has cost the Canadian taxpayer more than $300 million as legal fees. ISDS elevates the rights of corporations that is over those of the sovereign governments. ISDS awards can be financially devastating for host states. In fact, there's an interesting example which happened, with respect to Pakistan in the Tethian Copper versus Pakistan case, where they had received a 55.8 billion award, and which was larger than they had got a grant from IMF. That entire loan got wiped out in paying this award, which was passed against them for saying that they would not permit mining, and they were compelled to do it under this award, which was completely devastating and debilitating. The advent also of third-party funders has also created an unequal playing field, because third-party funders, do their due diligence and they only support the claims made by foreign investors, and the states can ill afford the expenses of these arbitrations, which go on for years to come, and the billions of dollars being awarded. Another issue which has also arisen is, are these tribunals which are adjudicating these disputes, are they competent to decide such disputes? These are some of the issues which I thought I would like to flag. And I will now request Ms. Ashwita Ambast, who is from the Permanent Court of Arbitration, to give her perspective from the experience which they have derived by, holding the oldest institution in the world which has been doing international commercial investment treaty claims. I'll request Ashwita to take the podium.
Good afternoon, everyone. Thank you very much, Justice Malhotra, for those very powerful remarks. As many of you know, the PCA is the host of this session, so as the host, I should start by thanking the organizers of Delhi Arbitration Weekend for giving us this opportunity once again of organizing a panel at this event. I'd also like to thank our wonderful speakers for being here and sharing their thoughts. Just by way of background, the PCA has in its long history a significant experience in administering disputes that have arisen out of treaties that deal with environmental issues. So, for example, the PCA is named explicitly in a number of treaties that concern the environment. For instance, the 1973 Convention on the International Trade in Endangered Species of Wild Fauna and Flora and the 1979 Convention on the Conservation of Migratory Species and Wild Animals states that all disputes that arise under those treaties will be resolved by arbitration, and those arbitrations will be administered by the PCA. Another way in which the PCA finds itself in contracts or in treaties that have to do with the environment is when the PCA is given a role in creating the tribunal that would hear the dispute that arises under that instrument. So, for instance, in the 1993 Convention for the Conservation of Southern Bluefin Tuna, it states that disputes that arise under it will be resolved by arbitration, and if a party is unable to appoint an arbitrator, or if the two parties are unable to agree on the presiding arbitrator, then the PCA Secretary General would make default appointments. So it's a result of being named in a number of treaties, but also having parties or tribunals that wish to use the PCA services by agreement in cases that involve the environment, that the PCA has amassed quite significant experience in administering disputes involving the environment. And some of these are publicly known interstate cases. One example is the case concerning land reclamation by Singapore, which took place between Malaysia and Singapore. The subject matter was certain land reclamation activities that had taken place between the waters of Malaysia and Singapore. And there were questions of environmental harm and whether there should have been an environmental assessment or consultations between the parties. The PCA is also currently administering a case under the Berne Convention between Azerbaijan and Armenia. So this is just an illustration of our past experience with these sorts of disputes. But of course, we're here today to talk about a very specific category of treaties, which is investment treaties or treaties that govern the protection of investments. And the PCA has had the privilege of administering a number of investment arbitrations, several of which have had some sort of connection to environment or environment-related issues. So in a sea of people who act as counsel, I see my role as the institutional person who could potentially do two things. One is talk a little bit about the kind of ways in which environment issues arise in the ISDS claims that the PCA has administered. I'll speak about these in obviously very broad and general ways because a number of these cases are confidential, so I'll try to be thematic and draw on public cases as is possible. And then I thought I'd cover some procedural features or innovations in the rules framework of these ISDS cases that could be necessary to address some particularities of ISDS cases that involve environment or environment-related issues. So turning to the first point, I think there are four ways in which environmental concerns have arisen in the cases that the PCA has administered. The first is that we've seen cases in which an investor would claim that the host state has somehow interfered with the investment, either by denying environmental permits that were necessary for the investment to come to fruition, or by alleging that there has been a failure to comply with certain environmental regulations in the making of the investment. The kinds of cases that have this sort of framework often involve environmental impact assessments, whether it's necessary, the sufficiency of environmental impact assessments, and so on. And a good example of this, which is public, is Bilcon versus Canada. It's a dispute that concerned the denial by Canada of a claimant's application to operate a quarry in a certain location after an environmental impact assessment was conducted of that quarry and its impact. The EIA had concluded that the project was likely to cause a number of adverse environmental impacts and also said that it was contrary to what they called community core values. And so the tribunal was then left with deciding whether this amounted to a violation of the the rights that the claimant had under NAFTA. A second way in which environmental concerns have found their way into ISDS cases that the PCA administers is where the investor raises concerns about the passage of certain environmental regulations by the host state. And these are typically regulations that have been passed perhaps after the investment took place. And so the typical claim that an investor would make is, well, when we made the investment, there was a certain climate, and then there is now a new climate that may have amounted to an expropriation of the investment or an indirect expropriation of the investment. And there are a number of examples of these kind of cases. I think a classic example, also public, is Vito Gallo, in which a federal state in Canada passed a legislation that essentially prohibited the use of a mine as a waste disposal site. And there was a claimant that owned the mine who was planning to use it as the waste disposal site. And they thought that this new regulation that had been passed, or I think it was a legislation that had been passed by the government, was something that resulted in the expropriation of their investment in that particular mine. A third category of the case, and this is kind of related to the second category but has a bit of nuance, is one in which an investor makes an investment within a particular regulatory environment, but making affirmative reliance on the benefits that that regulatory environment would give them. But then after the investment is made, there's certain changes to that environment by the host state, such that the benefits that the investor is able to receive are significantly diminished. And we see this kind of case arising quite a lot in the renewable energy sector, where an investor has relied on, for example, a certain tariff structure that has been offered by the state, which is then later altered in some way that affects the way in which the claimant's investment operates. And again, there are several public examples of these sorts of cases. There's Mesa, there's Windstream. These cases involved investors who had made investments in the wind energy, the renewable energy sector, but more specifically the wind power sector, in wind projects, and the alleged issues that had arisen had to do with a moratorium that was placed on wind projects, and obviously these cases concerned to what extent those particular actions affected the value of the claimant's investments. And a final type of case that we've seen, and I think this is quite interesting because you wouldn't expect this to be the kind of case that you see, is where an investor claims that the host state has failed to discharge its obligations to protect the environment, and that failure to discharge obligations has diminished the value of the claimant's investment. And this is interestingly seen in a case called Allard versus Barbados, where the claimant was operating a wetland sanctuary, and in order to get the license to do so, they had made a number of environmental impact assessment applications in which they referred to the regulatory framework that would operate around their project. And then that regulatory framework was changed by the respondent. And the claimant raised the question of whether this amounted to a violation of their rights as investors, because the changes to the environmental protections, which were detrimental to the environment, actually affected the claimant's investment in that particular sanctuary. So this is, of course, as I said, not an exhaustive list, but hopefully provides a flavor of the ways in which environmental concerns tend to come up in cases that are administered by the PCA. Let me now turn to the second aspect that I'd flagged that I would cover, which is whether there are particular features or procedural features in the frameworks of these investor-state cases that are necessary because these cases involve environmental aspects. And I should note that in the recognition of the fact that there might be a need for specific procedural features, the PCA did, as early as in 2001, develop special rules called the PCA optional rules for the arbitration of disputes relating to the environment or natural resources. So I'll try and draw on the framework of those rules as necessary. I think it's quite common for disputes that involve environmental issues to raise technical points or points that require expert opinion and that sort of extend beyond the purview of the legal expertise of counsel and the tribunal. And so it might in fact be quite desirable to have specialized expertise either on the tribunal itself or at the very least in the form of expert reports that are provided by the parties or expert assistance that's made available to the tribunal as they're drafting their decision. And the PCA's environmental rules, in recognition of this concern, does set up an open panel of experts and an open panel of arbitrators who can be nominated by the member states, who would then be available, or it would be a helpful resource, essentially, for people who are looking for arbitrators and experts with expertise or some background in disputes involving the environment. I think a second issue that tends to come up in cases involving the environment is the use of provisional or interim measures, which may be important in disputes where a party wishes to prevent further environmental harm that might have arisen in the context of the factual matrix in that case. And just drawing on our interstate experience and referring to a case that I did earlier in my intervention, in the case about the land reclamation between Malaysia and Singapore, there was a request that was made by Malaysia for provisional measures for this purpose, which was to prevent future environmental harm that may have arisen. In this context, I think a number of procedural rules, of course, already envisage the ability of the tribunal to grant provisional measures to protect the rights of the parties. But what the environmental rules of the PCA do slightly differently is that interim measures may also be issued in order to prevent serious harm to the environment. So there's another ground on which these measures might be issued, which could be helpful in cases that have an environmental aspect. A third procedural feature that might be helpful in the context of environmental disputes is site visits, because actually going to where the dispute is taking place or where some of the facts are playing out in real life could be helpful for tribunals as well as to experts to actually firsthand appreciate what kind of environmental concerns are arising out of a particular project site. The PCA has supported site visits in a number of its cases. And I think an interesting fact is that the founding convention of the PCA, which was drafted a long time ago in 1899, itself envisaged that it might be that a site visit is necessary in order to properly resolve a dispute. And so we see a number of rules of procedure in cases involving some sort of environmental aspect, making provision for a possible site visit if necessary. And the final point that I'd like to make is that disputes generally involving issues relating to the environment or natural resources typically tend to involve the interests of not just the parties to the dispute, but a wide range of stakeholders, which could include civil society, intergovernmental organizations, entities in the private sector. And so some things that need to be thought about more carefully from a procedural perspective are, one, rules on transparency, whether you want more material to be available to the public for reasons of accountability or public interest. And secondly, whether there should be some provision made for amicus submissions from organizations that may have something useful to say that the tribunal wishes to take into account. And I think there are a number of examples of tribunals actually entertaining amicus requests. I think those familiar with investment arbitration are familiar with Methanex, which is the classic case in which a number of NGOs attempted to become involved in the case by providing certain briefs, and they were also actually given the opportunity to listen into the hearing, which was made public in some part. I think their involvement was limited because they weren't really allowed full access, but there was some limited interaction that was permitted for those particular entities. So I think that brings me to the end of my time and also my comments. Thank you very much for this opportunity.
May I request Mr. Aditya Singh from White & Case, Singapore, to make his address.
Thank you, Justice Malhotra. I also want to add my thanks to the organizers of the Delhi Arbitration Weekend and the PCA for putting together this panel. So I've structured my remarks as follows. I want to briefly give you a broad overview of the ICJ opinion that's been referenced already by Justice Malhotra. I'll then focus on the likely impact of this opinion on investor-state arbitration. How does it strengthen or weaken the arguments that parties often make in these types of disputes? And finally, I'm going to take an example of a decided case and then visualize how the outcome might be different in light of what the ICJ has said in its advisory opinion. So let me first introduce the opinion. Less than 2 months ago, on 23rd July 2025, the International Court of Justice handed out its long-awaited advisory opinion on the obligation of states in relation to climate change. Interestingly, the ICJ's opinion is the third advisory opinion issued by an international court or tribunal in the last couple of years. We've seen the International Tribunal for the Law of the Sea and the Inter-American Court of Human Rights released their opinions in May 2024 and July 2025, respectively. I'll restrict my remarks today to the ICJ opinion. The opinion was issued at the request of the United Nations General Assembly, and the UNGA asked the following 2 questions. First, what obligations do states have under international law to protect the climate system and other parts of the environment from human-made greenhouse gas emissions? And second, what are the legal consequences of states of causing significant harm to the climate system and the environment? Now, we can spend an entire weekend to unpack the many nuances and layers of the ICJ opinion. But in 30 seconds, I'll give you the three key takeaways. First, the court opinion says that states have a binding obligation to protect the climate system from the harmful effects of greenhouse gas emissions, and that includes regulating private actors. Second, that states' climate obligations don't just emanate from the climate treaties, the UN Framework Convention, the Paris Agreement, the Kyoto Protocol, but they also arise under customary international law, international human rights law, the law of the sea, and that these form overlapping but separate obligations. And finally, if a state breaches the obligations, the legal consequences can be the cessation of harmful activity as also paying compensation for the damage. Now, 2 points before I get into the impact. One, the opinion does not directly address the relationship between climate change laws and regulations and international investment law, because that was not within the scope of what was addressed to the ICJ. And second, that while the advisory opinion is not legally binding, it carries significant persuasive force, especially in this instance, because the opinion was issued and adopted unanimously by all 15 ICJ judges, which is only the 5th time that a unanimous advisory opinion has been given in the ICJ's 80-year history. So let me now come on to the likely impact of the opinion. In addition to the advisory opinion, as Justice Malhotra pointed out, some judges issued separate declarations. And the separate declaration of Judge Sarah Cleveland, which has been referenced, is particularly relevant because it has 2 passages under a section entitled International Investment Law. And Judge Cleveland starts the section by noting the argument that investment arbitration proceedings often have a chilling effect on climate-related regulation. And then she concludes as follows, and I'll quote this part because it's important. The interpretation of investment instruments must be informed by states' obligations in respect of climate change under international law, including the stringent due diligence standards to which states are bound in implementing such obligations, unquote. So I'm reasonably confident that the ICJ advisory opinion more generally, and Judge Cleveland's specific note on this issue in the declaration will be cited in many, many investor state cases in the coming years. But what are some of the specific arguments that might be raised in ISDS cases going forward? So as you know, when investors bring ISDS claims, they most often allege that the host state has violated the fair and equitable treatment standard, the FET clause. And legitimate expectations are at the core of what the FET standard means. Simply put, these are reasonable, good faith expectations that an investor can rely on from a host state's assurances or regulatory framework at the time of the investment. And I think that the advisory opinion now sharply narrows what fossil fuel investors can plausibly claim as legitimate expectations under the FET standard. Because legitimate expectations hinge on what was reasonably foreseeable at the time of the investment. Going forward, legitimate expectations of fossil fuel investors would be judged in light of the known risk that states will regulate in the area of climate change. It will now, I believe, be very hard for investors to argue that they could not foresee significant climate-aligned tightening of regulations in carbon-intensive sectors. Equally, we can expect states to cite the advisory opinion to demonstrate that their regulatory actions to protect the environment and address climate change are not arbitrary, they are not unfair, but they are necessary for them to comply with their international obligations. This is because the opinion specifically says that a state's failure to protect the climate by mitigating greenhouse gas emissions may constitute an internationally wrongful act. Now, just as the ICJ opinion now sets a high bar for claims of fossil fuel investors, it can also be used by investors against states. And I think Ashwita alluded to how in certain cases you have investors relying on the failure of states to comply with their international obligations and instituting claims. Take, for example, investors in the renewable sector. They may now cite the advisory opinion to bolster their claims that a state unfairly favored carbon-intensive sectors over clean energy. If a government, for example, rolls back green energy incentives, the ICJ opinion gives them greater ammunition to mount a claim. So I want to end by giving an example of a case that was decided 3 years ago and comment on how the outcome might now vary in light of what the ICJ has said. And this is a case called Rockhopper Exploration versus Italy. It's a case that has generated much controversy. In 2017, Rockhopper, a London-listed oil and gas company, initiated an ICSID arbitration against Italy under the Energy Charter Treaty. To summarize it very simply, the claim related to Italy's ban on offshore drilling within 12 miles of its coastline. And in filing the claim, Rockhopper pointed to the regulatory flip-flop of the government of Italy with respect to an oil field off the Adriatic coast. In 2022, the ICSID tribunal awarded Rockhopper 190 million euros plus interest, about 250 million euros at the time. In holding Italy liable, the tribunal said that it was not second-guessing Italy's sovereign right to ban drilling, but it said that the sovereign choice, and I quote, may carry with it a concomitant consequence to pay certain compensation pursuant to internationally binding promises it made to foreign investors. So it held that once Italy had granted environmental approval, Rockhopper had a clear right to the concession, and taking it away amounted to an unlawful expropriation. Now, picture this case after the ICJ advisory opinion. The ICJ states that states have a binding duty under international law to protect the climate system, and that includes regulating private actors. So while Rockhopper succeeded in 2022, if the same facts were litigated today, the outcome may well be very different. If a state now bans drilling off its coast, it could now argue that this drilling ban was not just policy. It was not a policy choice, but a legal obligation under international law. So what the ICJ opinion does is that it transforms a state's defense from a sovereignty-based argument. We have a right to regulate. It transforms it from a sovereignty-based argument to a duty-based argument. We are duty-bound to regulate under international law. And so it narrows the space for fossil fuel investors to claim that they could not foresee climate-based regulation. The upshot, I'll close with this, is that the ICJ's advisory opinion has opened a whole new chapter. We can expect intense debate in the courtroom, intense debate before international tribunals, in academic conferences, and beyond. So we can expect a lot of action, and watch this space.
Thank you, Mr. Singh. May I request Mr. Mahesh Rai from Drew and Napier, Singapore, to make his comments.
Good evening to the esteemed guests, and thank you very much to the organizers of the DIAC and the PCA for inviting me to speak, and to my colleagues who have usefully touched on very key issues, and I'll try not to overlap with them. The topic that I propose to address really is whether the current regime of ISDS is purpose-built or still fit for purpose when it comes to climate change. Now, this seems easy to actually state, but this issue goes to the very heart of the system's legitimacy because it lies at the intersection between private capital deployment and what we call sovereign regulation. And through some points that I will raise, my answer to that question is that the answer is at present, it is not actually purpose-built to deal with environmental concerns. The current regime was in fact designed in the 1960s at the time when we were recovering from the worst the worst global conflict that the world had ever seen. And many countries were keen to attract foreign investment, and especially where in those countries legal protection, domestic legal protection were considered to be weak, the only way that you can attract foreign investors is through investment treaties or free trade agreements. Now, initially, in the early days, in the decades thereafter, the remedies that were passed were non-controversial because the tribunal's interpretation of arbitrary or discriminatory state conduct was relatively narrow. And now what has happened is that it has expanded to claims of indirect expropriation, where investors argue that regulation effectively undermines a profitability that they had expected to begin with. And so the controversy arises because measures that a government would normally take for the good of their people, such as climate protection, environmental regulation, or even public health, smoking issues, are being challenged through ISDS. The criticism of the current system really hinges on three problems that have been identified. The first is there's a general perception, not just from the global south, that the current ISDS system protects investment in traditional energy sources which are oblivious to the harmful effects to the environment. The second is that the current state of the investment treaties are seen as an obstacle to any measures that a government would like to put in place, like tax and subsidy regimes. And that hampers their ability to then achieve their climate change goals. And we have already seen this happening. Governments now delay or water down their climate legislation due to fear of claims. And you heard Justice Malhotra citing an example where the claim that is mounted is 3 times the amount of a nation's GDP. So they have to think very carefully before putting in place some measures that would address environmental concerns. The third criticism is on asymmetry of rights. Nation states often gripe about the fact that only investors can initiate claims, but why can the state not then counterclaim for environmental concerns or to bring public interest issues into the foray of ISDS? Now, the data tells a troubling story. Justice Malhotra had given you a preface to that. But some data points, and this is useful to actually analyze whether the current regime is fit for purpose. Where the final award was disclosed, fossil fuel investors have been successful in around 72% of ISDS cases. 7 of the top 10 largest ISDS cases, awards have involved fossil fuel interests, including a $40 billion award against Russia. The average amount claimed in arbitrations involving fossil fuels and traditional energy is $1.4 billion, and that is almost twice the amount in non-fossil fuel cases. And to date, there have been about 350 investor-state disputes relating to fossil fuel projects. That accounts for 20% of the total ISDS cases, and foreign companies have received northwards of $82.8 million through ISDS cases. The current estimates suggest that if you put in place global measures to combat climate change, that could generate about $340 billion in ISDS claims from fossil fuel companies in the coming decades. Along with the data, which tells a troubling story, the examples of past cases also show what my friend Mr. Aditya Singh had spoken about, which is the chilling effect that ISDS has on environmental policies. The first case that I want to talk about would be Kingsgate Consolidated in Thailand. In that case, the Australian company Kingsgate Consolidated owned the Chatri gold mine in Thailand. The locals in the vicinity of the mine were suffering from health problems, so they demonstrated high levels of manganese and arsenic in their blood. In response, the Thai government ordered the closure of the gold mine. And then they also refused to extend the license that had been granted to Kingsgate. Kingsgate proceeds to bring a claim in ISDS using the Thailand-Australia Free Trade Agreement and claim billions of dollars from Thailand in loss of future profits. This then led to what we call a chilling effect, because Thailand then decides to allow the reopening of the mine to the detriment of the locals. The second example is Rockhopper in Italy, which Mr. Singh has already alluded to on the facts. But what I want to touch on is the separate opinion that was appended to the award by Mr. Pierre-Marie Dupuy, and he set out his misgivings about the decision. He said that Italy had made no promise to grant the permit, and that the area of sea in question had been previously declared off limits to all companies because of very serious concerns about the ecological harmfulness of drilling there. But he concluded that his co-arbitrators were constrained effectively by the current regime, by the current state of the traditional treaties. They were constrained to rule as they did because, and I quote, "a tribunal constituted on the basis of the Energy Charter Treaty is only competent to assess whether or not the host state of the investment had breached its obligations under this legal instrument." In other words, they are boxed in by the express provisions of the treaty. These examples really reveal the live tensions at play. You have climate change on the one hand and investor protection that was really formulated in an era where we didn't have such severe environmental concerns. The second would be uncertain or inconsistent doctrine. And the third would be what many perceive to be a perverse compensation logic that privileges investor loss of profits over public interest or environmental damage. So what can we do in order to make the ISDS regime fit for purpose? I propose 4 such measures. One would be future treaties can include carve-outs for climate measures, and they can make it clear that non-discriminatory environmental regulation is not expropriation. This will then allow nation-states the latitude to implement measures to help them to meet their climate change goals. The second possible solution would be to limit fossil fuel protections. You can exclude fossil fuel investments from new treaties or try to phase them out from existing ones. The latter is easier said than done. And you could also, some have also proposed having a multilateral treaty that is signed to amend the existing treaties to put in place such limitations. The third would be to address the asymmetry of rights, allow counterclaims by states who can then mount a counterclaim against investors for environmental harm and restore some semblance of balance. The fourth would be to engender legitimacy, transparency, and participation. And this is where it starts breaking down, because some have proposed that hearings should be open and there should be a space for civil society, the community stakeholders, NGOs, those affected communities to be heard in investor-state disputes. Now, will these reforms necessarily make ISDS fit for climate change? We must remain realistic about it, because some of the remaining challenges would be the fact that we are dealing with a tapestry of existing old treaties, and there are thousands of them, where they've got grandfathering clauses, sunset clauses, and reforming these treaties will take political will and time. And that also is something that climate change activists are very nervous and anxious about, and they are agitating for change. At present, my conclusion is that the ISDS system is not fit for purpose to deal with environmental concerns, and the evidence that I've cited shows that. But if it is reformed to align with environmental goals, the current regime could evolve into a system that protects climate-aligned investments without deterring or hampering sovereign right to regulation in any way. Thank you.
Thank you, Mr. Rai. May I now request Mr. Sudhanshu Roy, Senior Associate from Foley and Hoag from Washington, to make his address.
Thank you, Justice Malhotra, and thank you to the panelists and thank you to the participants. So we've heard 4 very excellent and thought-provoking remarks from 4 very distinguished panelists, Justice Malhotra, Aditya, Mahesh, and Ashwita. So my task, I think, is a little bit difficult to follow in their footsteps, given what you've heard. And I'm also conscious of the fact that a lot of what I may have to say would overlap. So, and also conscious of the fact that I'm the last speaker. Before we enter into panel discussions and question and answers, so I'm going to try to keep my remarks brief. And the topic that I have to address, and in fact, the one that I chose for myself is, can states address environmental concerns through investment treaties? So it's a little bit different than what Mahesh talked about, because Mahesh talked about ISDS and how environmental concerns play into actual investor-state disputes, whereas I am going to focus more on state practice and treaty practice as regards how they address environment concerns. Historically, I'm going to be looking back, and I'm also going to be looking forward as to how states have done. Now, before I deliver my substantive remarks, which I've tried to break down into different segments, I want to acknowledge that the topic that we are dealing here is highly complex, right? Whether you're talking from the perspective of states who negotiate these treaties, or whether you're talking from the perspective of counsel, who, or even the tribunal members who actually interpret, apply, and advocate and argue under these treaties. So this is a highly complex issue. The answer is not always in black and white. We can discuss a number of steps here that states can take, for example, to address environmental concerns. But when you put yourself in the state's perspective, the situation is a little bit tricky, because it's not always about what the state wants. And I can say that because I have negotiated treaties, and I now serve as counsel for the last 9-10 years, arguing under these investment treaties before highly esteemed tribunals. So the job for the states is a little bit difficult, because, as I said, it's not always about what they want, but these negotiations can be highly complex, they can be highly political, and India is a perfect example, right? Because you saw, as Justice Malhotra alluded, in the 90s you had these hundreds of treaties that were negotiated, primarily in a bid to attract foreign investment. India was opening up its economy. There was a template that most developing states followed in negotiating investment treaties, and India was following in the footsteps of many states. So these treaties are the treaties that were negotiated in the 90s and 2000s are highly uniform in how they address different provisions, such as definition of investor in investment, substantive obligation, investor-state dispute settlement, right? Because the objective at that time was more focused on promotion and attraction of foreign investment, not so much on the state's regulatory and public policy objectives, such as protection of the environment, right? And then India changed its course when it started being subject to multiple claims, starting in around 2009 and 10. And then India decided that, oh no, this system is not working, because we are being subject to insurmountable amount of claims under various, by virtue of which various measures that the state has undertaken in a variety of public policy sectors are being challenged under those BITs. So India then decided to take a step back and then see how can we protect ourselves, how can we address our defensive concerns. So therefore, it terminated all of those treaties, and then it decided to renegotiate them on the basis of a new model text. So that was around 2015-16. But in that context, of course, if you look at the model text, it has several innovative provisions that a lot of the speakers today have alluded to in terms of protection of environment, protection of public health, and so on. But having a model and having a policy is by itself not enough. So that's why I said states face challenges, because then when you go in the actual world and negotiate these treaties, your counterpart is not always going to be on the same page and not always going to want treaties which, for example, have broad environmental protection obligations or very broad carve-outs that completely exclude the challenge of any public policy measures related to investments, to the protection of environment, which is why you now see that India is sort of trying to strike a middle ground between having very broad investor-friendly investment treaties that were negotiated in the 90s and then the approach that it adopted in 2015. So now it's trying to tread that very delicate middle path where it is trying to attract investment, but at the same time protect the environment. So, I mean, all of this is to say that we are dealing with a very highly complex subject, and I'm going to also address briefly as from the perspective of Counsel, right? From the perspective of Counsel, what I see when I argue cases, mostly on behalf of states, because that's the nature of my practice, and for the government of India, which I've done in the last 10 years, is that these cases are more often not about the law itself or the substantive standards found in the BITs, but these cases are highly technical, highly complex. You're dealing with very complex facts, right? And investors, more often than not, do not challenge the law itself. Like an investor is not going to go to a tribunal and say, oh, India is not competent or authorized to adopt such and such environmental protection law, right? That's never going to be the argument, because India is obviously competent. We have a parliament, we have our laws, and we are entitled to operate under that system. But the investor more often than not challenges how those laws are implemented in practice. So something that Aditya alluded to, for example, a very common argument in these cases is on legitimate expectations, right? What did the investor expect at the time it entered into the country and established its investment? And that is a question that comes up in almost every case. And the key point there, when I argue before the tribunal, is whether the state had provided a specific assurance to the investor that it would not adopt such and such environmental laws. Often we argue that the assurance had to be in writing, right? And that is, I think, again, that is a very complex question of fact. If you look at the investment jurisprudence, tribunals generally accept that to generate a legitimate expectation, there must be a prior written assurance by the state that it would act in such and such manner, but it's not always supposed to be in writing. So it's an evidentiary question. So if India adopts, let's say, an environmental law, or as it relates to an investment, or as it impacts an investment, the key question is not about India's authority to do so, but about how it impacts the investment and whether the investor had an expectation that such and such laws would have been implemented in this manner, or whether the investor, for example, had an expectation that it would not be that law would not have applied to that particular investor, but to some other investor. So these are very highly complex factual questions. Another example that I can give from my own practice is a lot of the times when these measures are challenged, right, tribunals and counsel grapple with the question of how the measure that is adopted by the state, let's say it's an environmental measure, is there a causal connection between the adoption of the measure and the harm to the investment? Now, that's a very delicate factual question, right? Because if the state can show that the harm that was caused to the investment was not directly related to the environmental measure or to the other public policy measure that was adopted, then there is no causal link between the harm that the investor suffered and the measure that the state adopted. And in that case, there are no damages, right? Even if the state is in breach of its international treaty obligations, if there is no causation, there are no damages. So again, all of this is to just come back and say that this is highly factual and complicated, and I just wanted to preface my remarks. Maybe I went a little bit too much into detail, but this is, I think we should recall this when we are looking at this question very broadly. I think we should acknowledge the complexity of the issue. Now, coming back to the actual question, I'm trying to be short here, can investment treaties be vehicles to enact or address meaningful environmental concerns? And the answer to that question is, I think I'm going to break that question into two parts, right? One is the substantive question, and that question is, can investment treaties be vehicles for substantive changes to the environmental laws and regulations, right? That is one question. And the other question is whether states can enact provisions in investment treaties that prevent or defeat claims by foreign investors that challenge those measures. So whether states can enact provisions in BITs for defensive purposes. And I think the answer to that question is yes. The answer to the former question, whether investment treaties can be vehicles by themselves to promote and protect the environment, I think the answer to that question is actually no, because if you want to protect the environment, you negotiate environment treaties, you reform your domestic laws. Why would you want to do it through investment treaties? So I think I'm going to focus on the second part, which is addressing a state's defensive concerns through environment treaties. And in that, I break it down into two parts: what have states been doing and what can be done in the future. Now, historically, as you all know, BITs have focused on investor protection, as we've seen in the example of India. Treaties that were negotiated in the 80s and 90s did not generally focus and address environmental concerns. That said, all of these treaties, if you read them carefully, they have certain provisions that the states can rely on in order to argue that an environmental law or an environmental measure is even if it impacts the investment adversely, does not necessarily amount to a breach of the treaty. And how is that? If you look at all of the treaties in the 90s, most of them have a general exceptions clause, which is to say that which allows the state to adopt measures for the protection of certain public policy concerns that, as I said, may otherwise violate the treaty. But if the state can establish that those measures were adopted in good faith and on a non-discriminatory basis, it does not amount to a treaty breach. And an example of that you will find in the India-France BIT, Article 12. I have it here in my notes. This was a treaty negotiated in 1995. India-Colombia BIT, Article 13. This was negotiated in 2001. Some of India's treaties, if you look at them, and free trade agreements, also include environmental exceptions for specific substantive obligations. So if you take the India-Malaysia free trade agreement, that states that measures that are, or environmental measures that are designed to protect public welfare objectives do not constitute indirect expropriation. So the expropriation provision in the India-Malaysia BIT has a specific exception for environmental measures. Other BITs, such as the India-UAE BIT, which was negotiated in 2011, has an environmental exception in respect of the imposition of performance requirements. Now, as you know, performance requirements are conditions imposed on foreign investors to drive their behavior and derive certain benefits for the states, such as when they say that an investor must export a certain amount of its production that it generates in India. Now, in general, BITs prohibit performance requirements, but this India-UAE BIT contains an exception which allows the state to escape a treaty breach if a performance requirement is intended to address an environmental measure. Some Indian BITs and free trade agreements, such as the India-Japan FTA, also have environmental provisions as part of the non-derogation clause, which is to say that a state, it is inappropriate, those provisions state that it is inappropriate for the state to encourage investment by relaxing health, safety, and environmental measures. So in the sense, a state cannot, as a means of attracting or promoting investments, derogate from its environmental standards. That is borrowed from the US treaty practice and the NAFTA treaty practice. So post 2016, as I said, states, including India, in the last decade or maybe even 15 years, have been more proactive in adopting environmental concerns and addressing environmental issues in BITs. But that is not to say that the previous treaties do not have mechanisms through which these defensive concerns can be addressed. Indeed, all of India's BITs negotiated since 2016, India, UAE, India, Belarus, India, Kyrgyzstan, India, Taiwan, India, Brazil, have a very strong exception clause that allows states to adopt measures, even if they're in breach of the BIT, as long as the state can establish a nexus between the measure and the protection of the environment. I have not seen the India-Israel BIT, which was, by the way, negotiated only last week, but I would be surprised if it did not contain a similar provision. The model text, obviously, if you've seen it, goes a little bit further because it tries to address the asymmetry critique that Mahesh was referring to in his remarks, in the sense it also imposes certain obligations on investors to address environmental concerns. Article 12 of the model BIT requires investors to voluntarily incorporate internationally recognized standards of corporate social responsibility, which may include protection of the environment. Now, the problem with that is it does not have a very focused enforcement mechanism to ensure that the investor complies with its obligation. It's entirely voluntary, and that is, I think, the case with most treaties, and I think that is because states find it very difficult. Developing states such as India find it very difficult when they're negotiating treaties to convince the other side to include these provisions which impose obligations on investors, because traditionally, most capital exporting states have viewed investment treaties as vehicles for protection of investors, and vehicles which confer rights on investors, not impose obligations. So I think that summarizes what states have been doing. What can states do? I think I'm going to address some of those points in the question and answer session. But I think the most important things the states can do is really focus and develop a very strong policy on international investment law. What is it? What exactly do states want? Do states want to have these treaties, or do they think that it is necessary in order to attract and promote foreign investments? If yes, then the states are going to have make some concessions and arrive at a middle ground, because having one-sided treaties which completely either promote investments or which only address states' concerns is going to be impossible. So I think a lot of states have, in recent years, decided that they just don't want the trouble of negotiating investment treaties because they don't want to be sued when they undertake legitimate environmental measures. South Africa, Brazil, Indonesia, these are examples of states. India is, as I said, walking the path in the middle, which is also trying to have these treaties, but also address its concerns. But I think if India wants an absolute immunity, it does not want to be answerable to an international tribunal in respect of its environmental protection laws, then it must ask the question whether it really even needs these treaties, because those measures are probably more important than protection of environmental. The protection of environment is probably a stronger public policy goal than having investment treaties. I think the second thing that the states can do is negotiate very strong and very clear provisions in investment treaties, because a lot of the problems that have arisen is because of these vague and imprecise standards that are negotiated, that have been traditionally negotiated by states. So I think states are doing quite well. They're becoming more sophisticated. India, for example, did not have an internal in-house legal team. Now they have a very large legal team which negotiates these treaties. They have capacity building and so on and so forth. They engage with outside experts when they negotiate these treaties. So I think it's very important to have clarity. The third thing that states can do is also enter into international environmental protection treaties. And what Aditya said, I think, about the ICJ is a very welcome development, at least for states, because it allows them to argue before investment tribunals that, it's not just investment protection standards that we have to comply with, we also have to comply with our environmental obligations. And because the applicable law in all of these cases is public international law, so tribunals are bound to interpret these different obligations in harmony with each other, so they can't ignore the environmental obligations and just interpret treaties in vacuum. States can also adopt joint interpretative statements which clarify the meaning of existing treaties, which India is doing. If you look at the joint interpretative statement that it has with Bangladesh and Colombia, they can also enter into meaningful dialogues with their counterparts and encourage non-disputing party submissions, so as to give guidance to the tribunal as to the meaning of specific provisions of the treaty. Right, so if a US investor brings a claim against India, or maybe that's a wrong example because there's no investment treaty. If let's say a Malaysian investor brings a claim against India concerning an environmental law or an environmental measure, India can enter into negotiations with Malaysia and say, look here, this is how we view this treaty, this is how we understand the tribunal should interpret this particular provision. If we are on the same page, then you come before the tribunal as a non-disputing party and make submissions. And if the parties give guidance to the tribunal as to how a treaty is interpreted, most often than not, tribunals are going to follow that guidance. I think I'm going to leave it at that, as I said, because I'm going to address some of the other points about what states can do in the question and answers. Thank you very much to everyone, and looking forward to the next segment.
Thank you, Mr. Roy. Since we are running against time, I think I'll open the panel to questions from the audience. If any of you all have a question before we make a concluding remark.
Hi, good evening all. I'm Anirudh Koteti. So this question is to Aditya or Ashwita, whoever wants to take it up. We spoke of the ICJ opinion on how it potentially sets up defenses for states in ISTS disputes. Do you think the ICJ opinion also sets up potential counterclaims that states could pursue against investors? I mean, it'll have complex issues of jurisdiction, but I'm sure having studied the opinion, that's something that might be possible. I'm curious. Thanks.
It's for you.
So I think, as I said in my remarks, the kind of arguments that the defenses that states will have when they are facing claims from investors, those similar arguments will also be available to investors when they are mounting claims. I think Ashwita, in her remarks, pointed to you that there is a type of environmental claim where investors are now launching claims against states saying that they have not done enough to protect their investments by complying with their obligations. So I fully expect that that will be used by investors down the line as well.
Any other question? Yes.
Thank you, ma'am. Good evening. My name is Surinder Kalra. My question is to Aditya. You started with the discussion that UNGA had proposed to ICJ for an opinion. Now, when the opinion has come, what is the duty of the UN General Assembly now to adapt it? And then, because this was initiated by some young environmentalists from small SIDS countries, particularly Kiribati. Immediately on 24th of July, there was a press conference and a webinar which I attended online by the Environment Minister of Kiribati. He said they'll go back to UNAG and then they would also be, then only it will become implementable. So what are the steps being taken by UNGA on that? And second is to Mahesh ji. that about the World Bank financing and other things, like even when Ajay Banga took over as the president, he said that none of the finances given by World Bank have been sustainable, and they wanted to move to other part of it, which was recommended long time back by ONGC, in the sense that blended finance. He came out with the concept of blended finance. And there, even the coupon rate for the poor countries was much higher than which was for the richer countries. So, in fact, what I feel is personally is that the judiciary sitting there has to have some knowledge and some capacity building about ESG, particularly there, as well as the judiciary in USA. And because of all these countries who are the most polluting, they are coming out of the Paris Agreement. They are not honoring. They have come out of the WHO and other things. Now, when you say that, why are you only insisting on energy being the most pollutant? Why not the war and all those things? If the First World War took place in Europe, Second World War took place in Europe, and Third World War was pseudo in Europe only. And all the ammunition, the president came out with a statistic, 350 billion worth of ammunition has been given to Ukraine by USA, which was half of it was given by, half of the amount was even given by European Union. That is the amount. And moreover, the Paris Agreement only talks about the temperature, 1.5 or 2. They don't call about CO2 or a methane or whatever the cause may be. We are only talking about energy producing this CO2 or anything. What about war? That is my question to PCA. Can we raise a question, arbitration in PCA about our entire European countries financing the war, or the American country financing the war? There is one SDG called 16. SDG 16 talks about peace. SDG 13 talks about climate. We are only talking about 7 and 13. And we are not talking about 16. Thank you.
Your question is actually layered. There are too many questions which have been combined in one. And a lot of these issues are political issues, which... All right, we'll have, would you like to respond to him? Just 1 minute. That's all right. Yeah. Yeah, you can use this.
Sure. I think that from the perspective of the PCA as an institution, the treaties that create the PCA are not jurisdiction-creating treaties. So they establish an institution and create a procedural framework that can be used if there exists consent in another treaty for the parties to submit a particular dispute for administration by the PCA to arbitration or any other method of dispute settlement. So I don't think that the PCA in and of itself, perhaps in contrast to some other courts, which do have jurisdiction creating underlying instruments. I think the PCA is kind of unique. It's more like an arbitral institution in that way. But that being said, I think that there are ways by which some parties are trying to use existing jurisdiction creating treaties to bring some part of their claims that pertain to ongoing conflicts to arbitration or to other international fora that exist. And I think that that's a matter of finding a treaty that has obligations and a dispute settlement clause, and then seeing which part of the claims, either for environmental harm or otherwise, fit within the jurisdiction of that treaty. I think that, for example, the existing case under the Berne Convention between Azerbaijan and Armenia that the PCA is currently administering, which I can't say much about except say that it exists, is an interesting case where issues of environmental harm in the context of conflict, they're being raised. So I don't think it's impossible, but I don't think that the PCA as an institution is in the way of a court creating jurisdiction. So you'd have to find jurisdiction in other instruments.
With this, we close this session because our time has now run out. Thank you for your attention. So we put a closure to this seminar discussion.
With this, we come to an end of this session. I request Dr. Sumit Kumar Sethi, Learned District Judge and Coordinator, Delhi International Arbitration Center, High Court of Delhi, to facilitate the Honorable Chair and the learned speakers by presenting them with a Prabhavali. A Prabhavali is a traditional ornamental arc crafted in intricate brasswork symbolizing India's rich heritage of craftsmanship and cultural expression. Set against a backdrop of hand-woven Indian textile, it reflects the country's enduring traditions of artistry and design. We hope it serves as a meaningful reminder of your time at the Delhi Arbitration Weekend 2025 and of the timeless elegance of Indian craftsmanship. With this, we close this session. I request everyone, and I hope to see everyone for tomorrow's session. Till then, have a nice evening. Thank you, everyone.
Thank you.